Mr. Chairman, Dr. Elizabeth Quart referred to the opposition camp, saying that they have there's a conspiracy for them. They just oppose for the sake of opposing. Well, I would like to solemnly point out here that I don't have any conspiracy. I will just speak on issues. I believe many in the pandemic camp also just speak on issues. So I hope the government or the CPA or the pro-establishment camp won't dismiss what we say just because who we are. Instead, we should have in mind the best interests of Hong Kong. So we will work to serve Hong Kong. Now, at the committee stage, a number of amendments have been moved. I would like to speak on some of the amendments. First one, Mr. Jeremy Tam's amendment. That is, the ordinance is a one-off arrangement. It doesn't apply to other situations. I believe Mr. Jeremy Tam's amendment is the most important of all the amendments. It also touches upon the core issue of one country, two systems, of what a co-location arrangement. Now, other members mentioned this in the past. This bill is against the Constitution. So that's why many members and others have said that this has to be one-off. There cannot be a second time. And that is a very important concept, the one-off concept. So that's why I think we should very seriously explore this amendment of Mr. Jeremy Tam. Why do we say the bill is unconstitutional? Now, I've heard speeches of the pro-establishment camp members. They say that many of them said the MPCSC has already made a decision, and the MPCSC is the highest state organ in the constitutional setup. Well, there are, that argument stands in a certain way. That is, the MPCSC has superior status. I think no one will dispute that. But at the same time, we talk about rule by a country by law. If we consider rule of law, then under any constitutional setup, there are powers conferred by the Constitution, but then there are restrictions on those powers as well. So the whole constitutional setup is that for the government, public organs, individuals, and so they will be conferred rights, but then there will be obligations and restrictions as well. So there's no exception when it comes to the MPCSC. Okay, we say that the MPCSC enjoys superior status, therefore we legitimize its decision. No, that cannot be done. It doesn't matter how superior the MPCSC is, there is still subject to restrictions under the constitutional setup. For example, in Hong Kong, in the constitutional setup, the CE enjoys superior status, but can she make law? No. That's a restriction under the constitutional setup. Now, this is an important issue, Mr. Chairman. In the basic law, there's a clear delineation as to under what circumstances we refer to the MPC and in other circumstances the MPCSC. For example, Article 22, the National People's Congress authorizes the Hong Kong Special Administrative Region to exercise a high degree of autonomy in accordance with the provisions of this law. So this power rests only with the National People's Congress, not the National People's Congress Standing Committee. But then Article 17 of the Basic Law, it says that laws enacted by the legislature of the Hong Kong Special Administrative Region must be reported to the Standing Committee of the National People's Congress for the record. The reporting for record shall not affect the entry into force of such laws. So here, the powers of the MPCSC are spelled out, and that's specific. That means when making the basic law, the MPC has conferred this power to its standing committee. And on the prescription of the powers of the MPCSC, again, there are specific provisions. During the second reading debate, I already raised this point. The MPCSC's terms of reference is derived from Article 67 of the PRC Constitution. And then Articles 17, 18, 20, 90, 158, 159, 160 of the Basic Law as well. Annexes 1 and 2 of the Basic Law also refer to the MPCSC. In all these articles and annexes, the scope of the powers of MPCSC is spelled out. That is, laws may be referred to the Hong Kong legislature again, and for the appointments of CFA judges and High Court justices and so on, interpretation of the Basic Law, amending the Basic Law, also, amending the electoral methods for the election of chief executive and the election and so on. So the MPCSC is given powers on all these matters. But please note, among all these articles, there is not one that says that the MPCSC may make a decision on other articles of the Basic Law. And through this decision, it's is in effect making laws for Hong Kong. But no, this is not the power enjoyed by the MPCSC under the Basic Law. Now, unless we say that the NPCSC has unlimited powers, or so-called residual powers other than powers conferred by the Basic Law. That means with residual powers, the MPCSC has immense powers. It can do whatever it wants. But if you know anything about the Chinese Constitution, you know that in the past there was a very weak basis for rule of law, and then eventually the legal system develops further, and that's the process of constitutional development. And an important part here is about constraining the powers of the authorities. And I think the legal profession in mainland would agree to that. So if there are no residual powers, but still the MPCSC can use any powers it likes, and it's very dangerous. It's a retrograde step in the development of the rule of law. Now, I support Mr. Jeremy Tam's amendment for another very important reason. If we look at the MPCSC decision, it actually does not cite any Basic Law articles or the, articles in the Constitution to affirm or support its decision. If the MPCSC's decision is not derived from the Basic Law or the mainland Constitution, then it's dangerous from a legal point of view. Now, some have said that this is because it's the continental law. So the continental law is not the same as the common law, which is practiced in Hong Kong. Now, Hong Kong criticizes this because from the common law point of view, and that doesn't hold water because on the mainland they practice continental law. Of course, I'm not a legal authority. I'm not a legal expert. But I'm sure you all agree that the continental law and the common law are the two major legal systems in the world. They are well established. And of course, for these well established systems, they must have strong legal basis. In the continental law, the emphasis is on statute law. So if they want to make a law, then they will probably refer to the past jurisdictions and past precedents and jurisprudence, and then make law, interpret the law. But then in the NPCSC decision on the co-location arrangement, we do not see any records or any laws or any articles being cited in support of that decision. Instead, the NPCSC just made a decision on the co-location arrangement. That's it. But if there's no basis for making that decision, then perhaps even from the point of view of continental law, this is not convincing. Well, there are many legal experts among us, Dr. Priscilla Leung, for instance, and I think she is conversant with mainland laws. So if she has a different view, I hope you should explain that from the point of view of the continental law. That is, for this particular decision, what is the vigorous legal basis for making this decision? You can't just say, well, because you don't know the continental law, so don't criticize. Okay, if you say this is based on continental law, then you have to explain that on the basis of continental law to convince people. Yes, we respect the powers of the NPCSC, but the question is, does it have the power to make such a decision to impose something on Hong Kong? Now, I respect the continental law because it's a vigorous system, but is there a rigorous basis to come to support this decision? What is the basis? So there needs to be a clear explanation. Otherwise, we're just saying that that's it, that's the decision, and that's the law. If that's the case, then no, it cannot be done again. That's why one-off is important, not the second time. That's important. That's the First Amendment. Now, second group of amendments, because quite a number of members moved those amendments. Dr. Fernando Zhao, Mr. Gary Fan, they have proposed set clauses. I'm just looking at it from common sense. The lease, the so-called lease. Here we talk about the Hong Kong style leasing out section of Hong Kong to the mainland, so it will become mainland jurisdiction. So the concept is lease here. With a lease, usually there is an agreement, and usually there's an end date to the lease, or how the lease is to be terminated, or even if it's a permanent lease, at least that has to be spelled out. But now here we're told this is lease, but under what circumstances would the lease end, or would the lease never end? Should there be a more specific provision? For the Shenzhen Bay Port, Hong Kong Port area, there is specific explanation of what will happen with the lease in future. So, in theory, when you lease something out, that means you can take it back. Even if it's on a permanent basis, there has to be a specific provision. So apart from this, I'd like to say, Mr. Chairman, about on the arrangement here. Now, I see on the screen no more names are shown, but at the committee stage, originally the chairman, the president has allowed 22 hours for this debate, if I recall correctly. But I think we started about 4 p.m. yesterday, and when we finished last night, we spent about 5 hours. This morning, together, it's less than 10 hours, I believe. And just now, the secretary is going to give a reply, and then they'll be voting. So altogether, at most, it's just 12, 13 hours. But initially, you told us there'll be 22 hours, so it's a far cry from that. On the screen, we see there are 60 members waiting to speak, but they won't get a chance to speak. Some of them have not even spoken at all during the committee stage. Why is it the case? Why is it happening time and again? Why is there a restriction time and again? So members are not allowed to speak. So, Chairman, I want you to give a clear explanation.